going on, guys? This is Mark Reel, the Fathers Rights attorney, and in today's video, I'm going to tell you about the 7 things I would change about family court in California to fix it. Number 7 is going to be the enforcement of California Penal Code 278.5. Did you know in the state of California, it is actually a misdemeanor to interfere with the custody of another parent? California, like many other states, already has a law on the books that says this is a crime. The issue, it is rarely ever picked up by the district attorney. It is rarely ever taken seriously by law enforcement. In fact, during my legal career, I have only seen this happen one time. And the gentleman who got the police to make the arrest, the DA to pick up the case, had an absolute mountain of evidence, dozens of missed visits, clear interference, great documentation, and regular follow-up with the appropriate people. So the first thing I'm going to do to help fix California family courts is I'm going to give those orders, those custody orders, more teeth by strictly enforcing California Penal Code 278.5. Now moving on to number 6. Number 6 is going to be to pass a time taken back law. Now, we've seen this get passed in the state of Texas. A time taken back law essentially says that if a parent wrongly does not receive the parenting time that the court has ordered, the court must order them make-up time. Now, in the state of California, this may include a restraining order that a TRO was wrongly granted. This may include a parent withholding custody during the other parent's time. But this will further give custody orders even more teeth by directing judges to order make-up time. I also think that ordering this make-up time is actually going to push judges to more recognize a component of the family code that I don't see getting cited enough, and that is that custody should go to the parent who is most likely to foster a positive relationship with the other parent. If the judge is consistently needing to order make-up time, it's going to signal to them that the parent that currently has primary physical and legal custody is not a parent who is fostering a strong relationship. All right, now moving on to number 5. Number 5 is going to be the private prosecution of perjury in family courts. Much like California Penal Code 278.5, perjury is almost never picked up by the district attorney's office in family court. And when I say almost never, I and the 5 attorneys I spoke to today could not recall a single time in which the DA picked up a perjury charge from family court. So I want to give the party that's being harmed by these perjured statements, I want to give them the opportunity to protect themselves and allow for their private attorney to prosecute perjury. If you make a statement on the record, very much similar to contempt, you should be able to file a document, file some forms alleging this perjury, and then privately prosecute it in front of that family court judge. This will go so far in preventing parties from playing fast and loose with the facts, from manipulating the facts, and from flat out lying. Imagine this. We see a ton of domestic violence restraining orders that are filed on simply false grounds. Now imagine if you could turn around and you've shown in the restraining order trial that they lied, that they perjured themselves in their filing. Now you can go after them for attorney fees and then either community service or jail time potentially. It provides a great sword to a party that has been harmed by an area that's lacking in family court currently. All right, moving on to number 4. Number 4 is going to be the elimination of Title 4D. Now, this is a meaty one, and there's a lot of misconceptions about Title 4D. Now, essentially what Title 4D does, when it was enacted to help states collect child support. And in short, the very simple way of what it does is for every $1 of child support that the state collects, the federal government gives them 66 cents to fund the programs for the collection of said child support. Well, that means this creates a perverse effect where the courts, in order to generate more revenue, can order more child support. So, do I think this is a major issue at the individual case level? I don't know. I think there could be a small impact. I don't think it's major. But when you put it across the entire country and every single courtroom, I believe this is the key issue on a federal level that needs to be adjusted. Let's take away the incentive for the states to collect more child support. Now moving on to number 3. Now, number 3 is going to be a little bit vague in the title, and I'll explain what I believe would be most impactful. So we need to adjust the child support laws, specifically how child support is taxed. Currently, if a man is paying child support, he is paying child support with post-tax income, and the mother is receiving said money and is not being taxed on it. So if a father is making $10,000 a month and they're paying $2,500 in child support, the first thing that's happening is they're being taxed as if they're being paid that full $10,000 despite potentially never seeing that money. They may be having their wages garnished, and so their employer's taking that money and giving it to the state. So the government is taking their taxes. After they take their taxes, they're taking their child support, and then the other party is not paying taxes on that money received. This creates a huge burden on the party that is paying child support. This could mean that they are paying upwards of taxes on 20 to 30% of their income that they never see. So how would I fix this? So we need to create a system or create laws that allow for child support to either be paid, number 1, pre-tax, or number 2, to be tax deductible. And if the state needs that tax base to remain where it's at, let's tax the party that is receiving the child support. They're the one that actually is receiving benefit from said money. Under the current system, in my opinion, the child support is creating what I would consider 2 poverty households. The party paying has such a large portion of their post-tax income going to child support that they must live well below their means to be able to survive, while we're putting extra burden on the party with custody and that is receiving child support so they cannot reach their full earning potential. So I propose either child support be paid pre-tax or there to be tax deductions for on-time child support payments. Okay, now we are moving on to number 2. And number 2 is going to be a big one. We need to rework the domestic violence laws in the state of California. Over the last 4 to 5 years, domestic violence laws have become so broad that I tell a lot of our clients that if you've been together with someone for more than a year, you've most likely committed domestic violence as it is defined by the California Family Code. So we need to tighten that definition. Number 2 is the process is being abused and we must course correct for that. A domestic violence restraining order gets filed and the judge, without hearing the other side, can grant temporary orders. Now, these orders can be extremely powerful in a custody case and can give a party the upper hand. So rather than domestic violence requests being used as a shield to protect the party and maybe their children, their family, it's being used as a sword to help gain leverage in their divorce, in their child custody matter. And this is something that must be corrected. My opinion is that we need to raise the burden for what is considered domestic violence in family court. I propose that the domestic violence or the standards for domestic violence and granting a domestic violence restraining order be similar to that in criminal court. If you accuse someone of domestic violence, you must prove beyond reasonable doubt that they committed these acts of domestic violence. If we don't raise this standard, we're going to continue to see it being used as a sword and not the shield it was designed to be used as. And last and most importantly, number 1, we need to pass equal and shared parenting laws. Now, equal and shared parenting laws, the gist of them is it's presumed upon divorce or separation that parents will have equal or close to equal custody. Now, this does not mean that the judges have no discretion. It means that we are creating a statutory starting point of 50-50 custody. We now have 10% of the states in the United States, Kentucky, West Virginia, Arkansas, Florida, and Missouri, all have a presumption of 50-50 custody upon divorce or separation. And some of those states dating back to as early as 2018 have seen amazing results in regards to these laws being enacted. Now, this doesn't mean if there's drugs, if there's actual domestic violence, if there's issues, if there's distance, that the judges can't deviate from it. We are simply creating a starting point. And I would propose the best law in the country is the Arkansas law, which presumes 50-50 custody unless the party requesting something different can provide clear and convincing evidence as to the best interest of the child being something different. So that would go a long way in improving custody, improving perception, and I think shortening cases and making family law something that is more palpable for everyone that is involved in a case. All right, so to wrap it up, we have number 7, we're going to enforce California Penal Code 278.5 strictly. Number 6, we're going to pass a time taken back law to allow parents to make up time missed. Number 5, we're going to allow private attorney prosecution of perjury in family court. Number 4, we're going to revoke Title 4D. Number 3, we are going to change the tax structure around child support payments. Number 2 is we're going to make modifications and adjustments to our domestic violence laws. And number 1, we are going to pass equal and shared parenting legislation. So those are my 7 items that I think would make a major impact on California family courts. What do you guys think about the list? Let me know anything else you would add in the comments.